If you set up a revocable trust but you mess up funding, your trust becomes useless and your assets will still have to go through the probate process. I'm going to show you exactly how to fund a trust in Georgia step by step so you don't mess up your trust and your assets will avoid the probate process and actually have asset protection. We're going to go over the 3 biggest mistakes that we see people make all the time and forces their assets to go through the probate process, the IRS trap that people make, and then we're going to give you a 7-step checklist to make sure that everything is set up correctly. Okay, the biggest mistake that people are going to make is they do not transfer the property into the trust when they set it up. And so this can happen when you set up your revocable trust if you are not using an attorney to guide you through the process correctly or check that the assets have actually been put inside of that trust. So what you need to do is make sure that you're using either a quitclaim deed or a warranty deed. And what that is going to do is transfer the property out of your name into the name of the revocable trust. That way the trust actually owns that property and you do not own that property. The reason that this is important is because if you pass away with that house in your personal name, it will have to go through the probate process to be distributed out to your beneficiaries. This is true even if you have a revocable trust set up. So we need to make sure that the trust actually owns that property. You no longer own that property, and we do that using either a quitclaim deed or a warranty deed. Once you have that document filled out, you'll file it at the county clerk's office in the county where the property is located, and they will transfer that property out of your name into the revocable trust, and then the trust will own that property. This is another big mistake that people make that hits them with a very large tax bill. If you have a 401k or a retirement account, you are not transferring that money into that revocable trust. All that you are going to do is name that revocable trust as a designated beneficiary if you want to, but the reason that we don't transfer that money into that revocable trust is because a trust cannot own a retirement account. Only an individual can own a retirement account. And if you were to go put that money inside the retirement account, that means you need to withdraw it from that retirement account, which means that you're going to get hit with a very large tax bill. The third biggest mistake that people make is how they title ownership of the assets sitting inside of that revocable trust. This could be for real estate that you put inside the revocable trust, or any bank accounts that you put inside of that revocable trust, or any designated beneficiaries that you name on your financial accounts. So if your family trust name is Smith Trust and you are the trustee and your name is John Smith and you created that trust on January 1st, 2026, the way that you need to have things titled is going to be John Smith, trustee of Smith Family Trust, dated January 1st, 2026. Your trust attorney that you're using to set up your revocable trust is going to make sure that you are using the proper naming convention. Just make sure that you are aware of how things should be titled so that you are doing all of that correctly, and have your attorney actually double check everything when you're done with it. A good trust attorney is going to help guide you through that whole process and then give you an audit on the back end to help make sure everything's titled correctly for that trust. So let's talk about the checklist. This will be the 7 steps that you need to take depending on the type of asset that you have to make sure you're actually putting the assets inside of that revocable trust, you have funded it correctly, and everything is going to actually have protection and avoid the probate process. So the first step is typically going to be for real estate. People put their family homes inside of a revocable trust. With that, again, you would use a quitclaim deed or warranty deed. You print that document off, sign it in front of notary witnesses per the local state laws, and you'll file that at the county clerk's office in the county where that property is located, and the clerk's office will actually process that paperwork and transfer the ownership of that asset out of your name into the revocable trust, and now the trust is going to own that asset. The next one is going to be retitling financial accounts like checking, saving, or investment accounts into the name of that revocable trust. Again, you need to make sure that you're working with your attorney to title things correctly, but you would either retitle those bank accounts from your name into the revocable trust name, or you would open up a new revocable trust bank account and transfer that money out of your bank account into that revocable trust. It's also a good idea to make sure you're removing the designated beneficiaries from those accounts. Otherwise, it can mess up the distribution of those assets because it could go to those individuals that you have listed instead of that revocable trust, which means that the assets would not get distributed per the instructions inside of your revocable trust document. The next one is going to be for your retirement accounts and your 401k, because you cannot transfer those assets into the name of a trust. You have to maintain ownership over those assets. What you can do is set the revocable trust as the designated beneficiary on those financial accounts. That way, when you pass away, that money is going to automatically be distributed out into that revocable trust. Now, you do need to make sure that you're looking at how that money will be taxed when you distribute that money out to a revocable trust compared to distributing out to your surviving spouse or your children, because those tax rates are different. You just need to be aware of that. The main benefit of naming your revocable trust as a designated beneficiary on those retirement accounts is that you get to control the distribution of that money out to your children or your surviving spouse instead of giving them a lump sum distribution. This is particularly important when you have children who cannot manage that amount of money, or you're worried about them blowing that money. The The next one's going to be your life insurance. Again, you would just name your revocable trust as the designated beneficiary on those accounts. That way that life insurance payout will dump into that revocable trust, and then you can control the management of that money and then the distribution of that money out to your children. That way you don't risk that money being blown or caught up in a divorce settlement. For your vehicles, this would be things like cars, boats, or RVs. You would just go to your local county tag office and ask them for the form to retitle the assets into your trust name instead of your personal name. And then you need to make sure that you're updating your auto insurance to match that the trust owns those assets and you no longer own those assets. The reason being is that if you do not update your insurance to reflect the new ownership over that property and you get into a car accident, they would have the right to not pay out any claims related to that wreck. This sixth one is going to be if you have any business interests, like a rental portfolio that you have inside of an LLC, or you actually own a business itself. What you can do is transfer the ownership interest of that LLC into the revocable trust. You need to update your operating agreement so that the trust can actually own that LLC membership interest and to reflect that the trust does now own it. You must also update your internal records to reflect that there was a transfer of ownership for the membership interest to the revocable trust and that you no longer are the owner of that membership interest. The next one is going to be personal property. So this would be jewelry, artwork, or heirlooms for your family. To make sure that the trust actually controls the distribution of those assets or manages them on behalf of your family, you would use an assignment of personal property document that would actually transfer the ownership of those assets into the revocable trust ownership. But you need to make sure that you are also listing those assets out on that trust document and that those two documents are going to match. If you want help setting up your revocable trust and you need guidance on funding that trust and making sure that you know exactly how to fund that trust in Georgia, we can help you with that entire process to make sure that all the assets you intend to go down to your family are sitting inside of that revocable trust so that they avoid the probate process. If you want help setting any of this up, click link in the bio, fill out the form, and schedule a time to talk to some more on our team.